Hi, this is Hani Bushra. I am an immigration attorney, and this is a video regarding some aspects of immigration law. I'm following up on a video that I just did about 2 weeks ago regarding the speed up of the process of applying for a family-based petition from a green card holder to their spouse or to their children under the age of 21 who are not married. And we talked in that video that in the month of July that there will be a speed up of the process, and that people who are in the United States in valid lawful status would be able to file an I-130, which is the application that proves that the green card holder is related to them, and the application for the green card, the I-4085, at the same time. Well, there has been an update since our last video, and this update, as usual, is typical of this administration and its desire to make things harder for even legal immigration. Just to give you a background, Congress has mandated a certain number of family petition visas every year. Within the family petitions, there's different categories. There's a category, for instance, of a U.S. citizen parent to their children over the age of 21. There's a category of a U.S. citizen parent for their children over 21 but who are not married. There's another category of a U.S. citizen for, towards their siblings. So Congress has divided the number of visas that they're going to give per year on the family categories into different categories. And they said every category gets a certain number of visas. And based on the anticipation of the State Department, because they are the ones who control all the embassies all over the country, all over the world, I'm sorry, based on their anticipation of when the certain categories will reach a certain date, okay, we issue this monthly thing called the Visa Bulletin, where we, the State Department tells everybody, hey, if you applied on so-and-so date for your family to come to the United States, we're going to start processing your visa, okay? So go ahead and send us your visa paperwork so we can start processing it. Now, the Visa Bulletin, when it was created mainly for people who are residing overseas. Slowly by time, there has been people who are been residing in the United States in legal statuses, for instance, on H-1B visas, on visas who are, for instance, visiting visas, on student visas, who now, because of how long things take, suddenly have their turn arrived at the same time that they were in the United States. And so these people had a process called adjustment of status that would let them apply for the green card in the United States without leaving. When the Visa Bulletin was created, okay, it was taking into account that a process of a case will take about 6-7 months. So when the date was issued in the Visa Bulletin to say, we're going to start processing certain cases, at that time there was no visas available for that date. But they were anticipating that within 6-7 months, which is the time by which we're going to finish your paperwork, your visa is going to be available at that time. Okay? And so about 6-7 years ago, the Obama administration came back and said, listen, it's not fair that the people overseas get a chance to, go ahead and prepare for, for example, for their visa interview by filing their paperwork 6-7 months before they're actually available, the visas. Why don't we do the same thing for the people here in the United States who are staying in the United States? And so the Visa Bulletin is this thing that comes out every month from the State Department. It gives us a list of when they're working on certain visas. For the longest time, until 6-7 years ago, it used to come out with only one chart. It's called the Final Action Dates chart, and it's the dates of when you go ahead and file for your case. When the Obama administration came and said it's not fair that all this time is only given to the people who are overseas, they created this new chart called the filing chart. And the filing chart is basically a chart that says, hey, if you're in the United States, okay, we will let you file a little bit early, like we let the people overseas file a little bit early, okay? Now, what's the benefit of filing adjustment status? Why is everybody so in rush to file for adjustment status? Well, let's put it this way. Number one, if you file for your adjustment status and somehow fall out of status after that, which is, for instance, if you had a student visa and you file for adjustment status, you finish your course of studies, you don't have to go back. Your adjustment of status lets you stay here legally. Adjustment of status gives you a chance to get a work permit and work in the United States. Adjustment of status gives you a right to travel. And so all of these are very good benefits for adjustment of status. That's why people want to file for adjustment of status. So the Obama administration came back and said, we have two charts now. We have a chart or the dates of the final action deadlines, and that's when visas are really available. And we have a chart called the filing deadline. And for the last 6-7 years, the filing deadline chart has been slower ahead. It was before the final actions deadline, final actions chart. In July, of 2019, the file and action chart is going to be current, which means that there is a visa. Right now, I have a visa available for you if you are a spouse of a green card holder, or if you are a child of a green card holder under the age of 21. But the Trump administration has decided to say that the filing chart is going to go back only to March of 2019. This is the first time we see it go behind the final action deadline. Okay, and the purpose of this is known. It's to delay illegal immigration. Okay, is it legal? There is a huge argument that it's not legal because the visas are available and they are essentially withholding the granting of the visa. And Congress said you have to give these visas if they're available. Okay, this issue is going to go to court. It's going to be litigated, but as usual, what the Trump administration does is that they don't care about losing in court. They care about just inflicting the pain and suffering at the process right now. And so, with these new rules, at this point, the following is true. Number one, you have to be somebody, who had a visa or an I-130 pending from March or before March 8, 2019 to go ahead and to apply for adjustment of status. So if you had an I-130 that was filed before that and you're in the United States legally, you can go ahead and file for adjustment of status. If you had an I-130 pending for that, and in July, for instance, you came for a visit here, you can file for an adjustment of status here in the United States. If you did not have that, my suggestion is still file an I-130. You're not going to be able to file a green card. If you're in the United States, still file the I-130 because it looks like the turn is coming up quickly. And because it's coming up quickly, there's a huge chance, that there will be people who filed in July, for instance, their I-130, that their turn is going to come quickly, because the visas seem to be available and people can apply for them. And so, the good news was that you could apply for your I-130 and your green card application in July of 2019. This is no longer available. If the only way you could apply for a green card in July 2019 if you are the spouse of a green card holder or if you are the child of a green card holder is that if you had an I-130 pending before March 8, 2019, you can still apply for an I-130 by itself and take a priority date with the hopes that, for instance, August or September of 2019 your turn was going to come because things are moving quickly, and so you can go ahead and do that. Couple of points quickly because we got a lot of questions about that. Number one, the date that they're looking for here is the date the I-130 was filed, not the date it was approved. That's number one. Number two, this is only applicable for the category of people who are people who are spouses of green card holders or they are children of green card holders under the age of 21. Number three, you have to be in lawful status in the United States. Lawful status, to give you 3 quick examples, if you had an asylum case pending before the asylum office, not in court, asylum office, and you filed for your asylum before your previous status, like for instance your visit visa has expired, you're on lawful status. If you, for instance, are on a student visa and you file before your student visa expires and you leave your school, you're in lawful status. If you are on H-1B or employment visa and you file before the employment visa expires, you are in lawful status. So all these people can go ahead and file for the adjustment application if they have an I-130 filed before March 8, 2019. As usual, we thank you so much for watching us. Please send us your questions and we'll try our best to give you our answers. Thank you very much and have a good day.